Hi, everyone. Thanks for joining us. My name is Cecile Holtz. I am a partner at Arjun Bridge Advisors. And we've put together a series of videos on interesting financial planning topic. And January is our month to focus on estate planning with our clients. We've had really good success with using special needs trust with our clients. It can be a very, very powerful planning tool. So we wanted to invite an expert today to discuss this important topic. Liz Gray here is a partner at the law firm McKinlish Lillard with offices in Fairfax and Leesburg. So Liz, welcome. If you don't mind, I'd love to ask you a few questions and ask about your expertise around special needs trust. So I'd like to start by saying that this is really meant to focus on special needs. We're not going to touch on the basics of what a trust is, etc. So if you have questions about that, I would refer you to our website, arjunbridgeadvisors.com. We have some videos about the basics of estate planning. But I know it's hard to do, but Liz, sorry, in a couple of sentences, do you mind explaining what a special needs trust is?
Sure. So a special needs trust is a trust that will hold assets for a beneficiary that is special needs and is on means-based public benefits like Medicaid, a Medicaid waiver, or SSI, which is supplemental security income, and allows that individual to maintain those eligibilities for those means-based benefits. But those assets in that special needs trust don't count against that person. That person can only have $2,000 or less in assets right now in order
to very little.
Yeah, there's not a lot of money. So this is like a slush fund to be used for that person to pay for those things that the public benefits don't pay for.
Do you have a couple examples of what the funds can be used for? I feel like we always think of special needs trust should only be used for basics, but
I do actually. Over the years, I've served as guardian for a lot of people with special needs that don't have family members, or the family members aren't available to serve. And I was guardian for a gentleman with Down syndrome who had very little money. He had a little bit of money in a special needs trust, and he needed surgery and hip surgery. And the doctor that Medicaid hired gave me his opinion of what he was going to do. And I really felt like the doctor was taking the easy way out with his recommendation. And Medicaid said they weren't going to pay for a second opinion. I wanted a second opinion. I used the trust money to get a different doctor to give a second opinion. I was able to bring that second opinion to the first doctor, and the first doctor changed his mind. And I was so grateful to have that ability to do that, because it was at least $1,000 to go about getting this second opinion that this gentleman just didn't have.
Yeah, that's a great example.
Yeah, but we've used it to send this gentleman to a dude ranch. He really liked horses. He wanted to go to a dude ranch. I've used it to get a new HD TV, a Wii Fit. I've used it for a new car, a lot of different things that you don't think about when you're talking about you can only have $2,000 or less for the rest of your life.
Yeah, it just allows someone to have a much better standard of living. And
yeah, it really enhances their life in ways that they are not enhanced just being on public benefits.
Okay. So you mentioned you were a trustee or a guardian for some of your clients, and that's something that comes up a lot when we have those conversations with clients and they're trying to plan. It's an overwhelming task. It's choosing your trustees, choosing who's going to take care of your child or the person you're taking care of once you're gone. So how can you tell us a little bit about that process?
Sure. I am not a big fan of having family members serve as trustee of a special needs trust. There's a lot of reporting requirements with a special needs trust to Medicaid and Social Security. And there are a lot of things that you can accidentally pay for that will gum up that person's eligibility. And then the final thing is that sometimes family members don't have the best interest at heart, technically, and don't have that neutrality that a professional trustee can do. So I'm a big fan of having a professional trustee and maybe having the family member as what we call a trust protector, so that
Mm-hmm.
the family member can fire and replace the trustee if they don't like what the trustee is doing, so that they do have some input, but they're not making those decisions that are so crucial to this individual. The sibling can stay the sister or the brother or the
Right.
and not step into the shoes of parent, which can gum up relationships a lot of
Right.
times.
And speaking of family dynamics for a second, another thing that we see a lot is a difference of opinion between family members. So we'll have a client come in and say, "Oh, I'm really interested in setting this up, but my spouse or the grandparents don't agree that there is a need for special needs trust, that they don't even agree that the child or the relative even has special needs." Do you have a recommendation as to how to navigate this?
There is no reason why one parent can't set up his or her own special needs trust. There
Mm-hmm.
doesn't have to be a joint special needs trust with both parents. So if the spouse doesn't agree and you think this is going to be a real possibility, set up your own special needs trust. Work with you in figuring out how to get the money into the special needs trust. But there's no reason why you can't do it yourself. You don't have to have both parents on the same page. And then you also have the ability to do what's called a letter of intent or a memorandum of intent, which is really your piece that's private that goes along with the trust to explain to the trustee the family dynamics, who the doctors are, what the child is like, what you wish for that person, that kind of thing.
Okay, that's good to know. And how when does a special needs trust get funded? Is it, you know, during someone's lifetime, or is it upon their death, or can it be any way?
It can be any way. Usually the parents are the walking, talking special needs trust. While they're alive, they're paying
Mm-hmm.
for anything that the public benefits don't pay for. So for
Mm,
planning purposes, I'm really looking at what happens when you're deceased, when you're no longer there to advocate and protect and assist this person. Who's going to step in to your shoes and do this for you? And what kind of funds are going to be available and accessible to pay for these things?
mm. Yeah, that's a really great tool. What about able accounts? We I've been hearing so much more recently about able accounts, and sometimes, some people are telling me, "Do I need a special needs trust? I already have an able account." What's your take on this? Can we marry the two, or what's the best approach?
I'm a big fan of able accounts for some of our clients. And it's a great tool in our toolbox of special needs planning, to have an able account and a special needs trust. They work really well together, but there are limitations on both. And so if you have the ability to fund a special needs trust and open up an able account, I would do both.
Mm-hmm. And when should people reach out to you to set these up? Is there best time to set it up? I mean, is yesterday the best time to set it up, or?
Um, Probably in the teenage years,
Okay.
but really there is no bad time because we don't have crystal balls. We can't predict when you're going to pass away. So get the planning done. If you do it ahead of time, you can always change it and tweak it. And it's a lot easier to do if you've got the mechanics in place already, um,
Mm-hmm.
than to do it on an emergency basis.
What happens, Liz, if I think you were talking about the teenage years, and as you probably have more clarity about someone's condition as they get older, but what if you set up a special needs trust thinking that a child might have a disability, and then they grow out of this disability, so to speak, they do therapy and they do great, and then they never end up needing this trust. Is there a downside of setting a trust that's useless?
No, there will be several options. So, like we talked about, generally the trust isn't funded or the money doesn't go into the special needs trust until you die. So, if you see your child has recovered, you can change your beneficiary designations and just leave that trust as an empty trust, basically.
Mhm.
Or the trustee has discretion in the special needs trust, 100% discretion to use the money as he or she sees fit. So if you've got in your letter of intent or your memorandum of intent that, if my child is able to be independent, give him or her a chance to use the money and let him have the money. And
Mhm.
I'm a big fan of that. If I'm the trustee and this person is earning more money than me and doing great in the community and
Mhm.
doesn't really need this, I'm happy to pay it out to that person and have them set up to manage their own money.
Good. So it can be flexible as well. You're not locked in anything. It's not like an irrevocable trust where you can't do.
It becomes irrevocable when the parents die in the way that I draft them. But because the trustee has so much discretion, there
But
is
you
the
have a way out. Okay. That's good advice. What another pretty common misconception that we hear about is about the clawback clauses with those special needs trust and the possibility of Medicaid getting the money back after someone dies. Do you mind telling us a little bit more about this?
Sure, sure. That is a misconception. There are two types of special needs trust. One is a special needs trust that I could set up for myself with my money. Maybe I inherited money. Maybe I got a personal injury settlement, or I worked and I have a retirement account. My money goes into what's called a payback or a D4A based on the code section, special needs trust that is paid back to Medicaid to the extent Medicaid paid when I die. So that's a first party payback special needs trust. The other type is a third party special needs trust. And that is if my mom and dad set up a trust for me and put their money in it for my benefit when they die, that trust does not have a clawback. That trust can be left to anybody mom and dad select when we're creating the trust. So it doesn't have a clawback, and it is one of the mistakes I see that people make a lot of times that don't have experience with these types of trusts. So you've got to make sure that you're working with somebody that knows the difference between first party and third party.
Yeah, someone going to an estate attorney who specializes like you in special needs trust, that you can't just go on legal Zoom or anything like that for this kind of work. That makes me think too, is there any something specific to Virginia that if each state have different uh laws around special needs trust and you really need to get a local attorney?
Every state has different rules with respect to Medicaid. And
Uh,
so in some states, Social Security is linked with Medicaid. So you only get Medicaid if you've got SSI and vice versa.
mm,
Virginia is not one of those states. But if I know the parents are thinking of retiring to Arizona, I'm going to have a colleague of mine in Arizona review the trust to make sure it complies with Arizona law. And
mhm.
I always include a clause that allows the trustee to amend the trust just in case the person moves to a different state so that it would comply with the different states' laws.
Okay. Wow, you really know your stuff, Liz. Thank you. Um, Great. And I would like to say, for anybody listening to this who'd like to reach out to Liz, please let us know. We'll be more than happy to connect you. As you can tell, she's a wealth of resources and knowledge. So if you have a need, please let us know and we'll make sure to connect you. Well, I really want to thank you for your time, Liz. We
Thank you.
did a lot today in a very short amount of time. So we're very thankful that we were able to have you on today.
Thank you. Thank you.